Welcome to Blockchain Explained, the podcast about opportunities, challenges, and trends in blockchain technology. Whether you're a beginner or an expert, a developer, or just crypto curious, this podcast is for you. It features industry leaders and government officials discussing the world of distributed ledgers, cryptocurrencies, and the metaverse. And now, here are your hosts, Alan Rechtschaffen and Kelly Wicker.
Welcome to another episode of Blockchain Explained. I'm Kelly Wicker, Director of the Science and Technology Innovation Program at the Wilson Center, and I'm coming to you with my co-host, Alan Rechtschaffen, who chairs the Digital Assets Forum here at Wilson. We're joined today by Colin Lloyd, a partner in Sullivan Cromwell's Commodities, Futures and Derivatives, and Capital Markets groups. Colin regularly advises clients in relation to blockchain, digital assets, and other emerging financial technologies, and he's been recognized as a cryptocurrency, blockchain, and fintech trailblazer by the National Law Journal. We're privileged to have you here. Thanks so much, Colin. Now, I'm going to kick us off by confessing I'm going to be a little out of my depth today because we're talking finance. Alan, you teach at NYU on financial instruments, so you're very much in your element here. I know we were hoping to have special focus on the court ruling on Ripple. Can we break down the importance of that case for those of us who are not as well versed with the world of finance and securities?
Sure. So I'll kick this off, Kelly, and I teach at the law school, but I teach financial instruments, but I teach it at the law school, and so much of what I do is focused on the regulatory construct around financial instruments, and cryptocurrency is a classification of financial instrument, and definitionally, it's important to understand how a financial instrument works in order to understand the regulatory construct around that financial instrument. So something doesn't have to be called a security to be a security or be called a commodity to be a commodity. And definitions become important based on use cases. So Colin and I know each other a long time now. We've been working together because Colin makes my life a lot easier because I'll have him be a guest professor at NYU. So I'm going to ask Colin to really kick off and tell us what happened in the Ripple case. And what I'd like to do, Colin, if it's okay with you, and with Kelly's introduction, I think it's appropriate, is really break down how securities laws apply to this incredible technology of blockchain and the use cases like cryptocurrency, and also how the commodity laws and various financial regulatory constructs, aside from securities and financial regulatory constructs using commodity laws, what regulatory framework there is today and what regulatory frameworks are proposed. And sort of kicking it off with the story of the Ripple case, I think is a great place to start because it sort of encompasses everything I just, gave you 40,000 foot overview of.
Yeah, so the case is super interesting because, there is not a kind of a functional definition of what is a security. The definition of a security in the securities laws is essentially a list of different things that Congress decided in 1933 and 1934 would constitute securities. So you have stock, you have notes, you have later on certain types of options contracts. There is, however, a kind of catch-all term for an investment contract. And that was interpreted by the Supreme Court in the seminal Howey decision from 1946, which related to contracts concerning the cultivation of orange groves. That an investment contract is a situation where you have a contract scheme or arrangement whereby there's an investment of money in a common enterprise with the expectation of profits from the efforts of others. And because cryptocurrencies obviously weren't invented back in the 1930s or in the 1940s, when the SEC is seeking to apply the securities laws to cryptocurrencies, in most instances, they can't just look at the classic kind of prongs for stocks or notes or things like that, because most cryptocurrencies don't have the kind of economic and contractual attributes of traditional stock, for example. And so they have to go to this catch-all term for investment contracts. And what was interesting about that case, the case did a few things. One is the Judge Torres in the Southern District of New York, said that the cryptocurrency, in this case XRP, all by itself is not a security for the same reason that the orange groves in that Howey case that I mentioned aren't themselves securities. Instead, she looked at all of the facts and circumstances associated with particular transactions in XRP that were the object of the SEC's lawsuit. And she went kind of category by category for these different transactions, and she analyzed the facts and circumstances of each of those. And the question was, were those particular transactions themselves investment contracts? She looked at 3 different categories. She looked at one category, which involved Ripple, the sort of company that sort of developed some of the software and ecosystem around the XRP cryptocurrency. She said that, well, when they went and they sold XRP pursuant to special contracts with certain institutional investors, where they gave marketing materials to those investors talking about all the things that Ripple would do to promote the value of XRP. They had lockup provisions and indemnification provisions and other things that you would kind of customarily see in some sort of offering, securities offering context. She said, well, those particular sales were investment contracts. Now, I think what she did next, interestingly, is she looked at other type situations where Ripple sold XRP, both kind of blind bid-ask transactions on anonymous exchanges, as well as when Ripple just kind of distributed XRP to certain potential users of the cryptocurrency or to employees, sort of as inducement to get them, as sort of a reward for their involvement in the ecosystem. And she said those 2 latter categories did not involve investment contracts because the manner in which Ripple was offering and selling XRP in those instances didn't satisfy the 3 Howey prongs. Specifically, she said that when Ripple was selling XRP anonymously on exchanges, and they were only about 1% of the volume on the exchanges at that time, that kind of lacked the indicia of investment contract because the people who were buying on the exchange had no idea, whether they were giving their money to Ripple to invest in Ripple's enterprise and profiting from Ripple putting that money to use to develop that enterprise, or whether they were just giving them to some other third party who happened to own, XRP. She also said that when Ripple was giving out, the XRP to these kind of participants in the community, that they weren't making any kind of investment of money because they weren't having to, give any specific kind of consideration for to receive XRP. Now, I think there's been a kind of headline misinterpretation of a decision. A lot of the reporting on it, I think, has been a bit misleading because it's been suggested that Judge Torres was saying that XRP is a security when it's sold to institutional investors, but not a security when it's sold to retail investors on an exchange. That is not what she's saying. What she said is that XRP itself, in no instance, is a security. It can be sold, however, as part of an investment contract. And in deciding whether it was sold as part of an investment contract, she looked at the facts and circumstances of what Ripple was actually out there saying and doing vis-a-vis the purchasers, which was a different set of statements and representations and agreements for the institutional purchasers than what it was when they were just trading anonymously on exchanges. And she was not suggesting that for some reason retail investors, when they buy cryptocurrency, don't deserve the protections of the securities laws versus institutional investors getting those protections. That was not what she was getting at. What she was getting at was what I think most would say is the right way to look at Howey, which is that you have to look at the facts and circumstances of each transaction on its own, and it happened to be the case in her analysis that the facts and circumstances in those kind of blind transactions on an exchange didn't have the indicia of an investment contract.
So, Colin, let me try to understand. So you're saying that there's this thing that they made called Ripple, which is the cryptocurrency. And maybe you'll explain what the use case is for it also. But there's this thing that they made, and that thing is not a security. So if I make a stock, it is a security because stocks inherently have something about people making money together built into them. But this thing that they made, this thing called Ripple, was out there. It's just an item. It's a commodity, for lack of a better way to describe it. It's a thing that's out there, but transactions around that commodity, that item, those transactions are securities, but the underlying item is not. Is that correct?
But that's right, and again, that's not unusual, right? So the courts have developed tests for when something constitutes a stock, and they look at things like the ability to participate in profits via payment of dividends, the ability to participate in governance, things like that. For something, however, that is not a stock and it's not a bond, right? Not a note, right? It's not an evidence of indebtedness. Then you kind of have to look to this catch-all. And the investment contract catch-all has been used over the years for all kinds of different instruments that are not themselves, securities, right? You have, as I said, in Howey, there are orange groves. There are cases that involve someone selling whiskey cask. There are cases where people are selling kind of live animals that are, being used to breed other animals. There are, cases involving payphones, right? Clearly, none of those things themselves are securities, but they can be sold as part of an overall investment contract scheme or arrangement in circumstances where someone is giving their money to the promoter in exchange for the promoter making promises about what the promoter is going to do, with respect to that person's money in order to create profits for them, where there's some sort of pooling of money as among the different investors, which is horizontal commonality, or pooling of money as between the investors and the promoter, which is what the courts refer to as vertical commonality. But that has nothing to do with respect to the underlying asset. You could create an investment contract out of darn near anything, and that doesn't change the categorization of the underlying asset. It results in securities laws applying to the relationship between the promoter and the asset purchaser.
But the flip side of that is that you could also create an asset, an animal that in and of itself is inherently an investment contract, correct? So if I say that I'm going to issue a cryptocurrency and everyone who buys that cryptocurrency gets a percentage of the profit of some business or percentage of some financial arrangement that I have, then that would in and of itself be a security, whereas the use case of Ripple is what made it different. So it's not, I think I'm understanding that it's not a blanket statement that cryptocurrencies are not security. It's saying that this particular use case that this Ripple item was used for, and maybe you can go into the use case a little bit, that was not a security in and of itself. Is that correct?
Yeah, so I think it's fair to say the securities laws, at least the categorization of things as securities, are technology neutral, right? If I took some stock and I put it on a blockchain, I use blockchain technology to record who has ownership of the stock, it's still a stock, you know. And the fact that I might call it a crypto stock doesn't change its legal categorization. Here, and this is true, I think, for most of the most widely traded cryptocurrencies, it doesn't have those instruments, and in fact, it doesn't represent any kind of contractual relationship whatsoever between the promoter or issuer of the asset and the holder of the asset. There is nothing inherently about XRP, just as there's nothing about Bitcoin or Ethereum or Dogecoin or any of these other coins that creates some sort of contractual relationship, some entitlement, some legal relationship between the holder of the asset and the promoter or issuer. XRP happens to have, a use case principally as a means of payment. The thing that it's used most commonly for by Ripple is as a means of facilitating cross-border payments in a way that is, in their view, cheaper and more efficient than the kind of international wire transfer processes that otherwise, would apply. But importantly, to your point, Alan, if I own XRP, I can't go to Ripple and demand that they pay me anything. I have no right against them. And that is very different from someone who owns stock or bonds or any other type of traditional security.
This actually, this is entirely really helpful because a lot of what you're talking about that the news has been talking about in a certain way, that's what I've been reading. So this concept of the decision meant that sometimes it was a security and sometimes it wasn't. The way that you're describing it sounds much more clear. Like it's not that XRP is itself a security or not a security. It is when it is being deployed. If it's being deployed in a contract, that would constitute a securities arrangement. This is all very difficult.
A contract that is that meets the criterion of an investment contract. If that's the way it's being distributed, that contract is the problem, not the underlying stuff that they're moving around.
So I'll give you an example, Kelly, of another case that I think makes it easier. I mentioned there was a case about payphones, right? And so in that case, like if I bought a payphone, okay, and I was responsible for maintaining it, and I collected all the, I guess used to be quarters that people would use, or dimes, depending on when you were using it, to use a payphone, then clearly that payphone's not a security. Right?
Colin, you may have to, for our younger viewers, have to explain what a payphone is, but that's okay. Forget about the quarters.
Yeah, yeah, exactly. But if instead, what I did is I bought up a bunch of payphones, and I went to you and to Alan and to all the viewers and said, hey, if you give me this money, I'll lease the payphone to you, but I'll manage the payphones. I'll keep them, in operation. I'll collect the money, and I'll distribute to you a cut of the money that I receive. Okay, that was held to be an investment contract. The payphones themselves were still just payphones, right? The Howey case is another example. In that case, you had someone who was saying, I'm going to sell to these people orange groves, okay? But in addition to that, they would enter into contracts with me where I would agree to maintain and cultivate the oranges, sell the oranges, and then deliver a portion of the proceeds back to the people who purchased the orange groves from me. The orange groves themselves were not securities. The oranges were not securities. If someone bought Mr. Howey's, oranges at the supermarket and then sold them to someone else, they weren't engaged in a securities transaction, okay? But what was a securities transaction was the offer and sale of this overall arrangement, where instead of someone buying stock in some company that managed a bunch of orange groves, they, at least as a formal matter, bought the orange groves themselves together with this, set of land management contracts. And it's sensible, right? It was meant to avoid situations where people would kind of have form over substance to get around the securities laws, but really what they were selling were interest in a business enterprise, okay? And the difference here is that what Judge Torres is saying is when Ripple was selling the XRP to institutional purchasers, they were doing so pursuant to marketing arrangements and contractual arrangements, which kind of amounted to selling to those purchasers kind of an interest in Ripple's business enterprise. But when Ripple was just blindly selling XRP on exchanges to people, and people had no clue whether they were buying from Ripple or they were buying from Alan, those people were not participating in any kind of investment contract. They were just buying an asset.
But Colin, you mentioned Ethereum before. What about if in a case where miners know that if they record data in a blockchain, they're going to get, let's call it a check, but they're going to get a little bit of Ethereum for doing that, or a little bit of Bitcoin if they're mining a Bitcoin. Isn't there some sort of implicit contractual arrangement that's there that could be viewed as an investment contract that's inherent to the underlying item itself, unlike the orange grove?
I'm not so sure about that, because that just means that the technology operates in a particular way where someone can earn more of the asset by doing it. The reason it's called mining, I think, is by analogy, but the analogy is I think an apt one, right? The fact that that by participating, digging a hole into the ground and going there and finding the underlying mineral, that you're going to earn something by performing that work doesn't mean that you have some sort of investment contract with the underlying natural environment, right? It's a technology itself that inherently produces the ability for people um, to participate economically in the functioning of that ecosystem and be rewarded for doing so. But that's not a contract with a particular enterprise that is kind of a legally cognizable issuer that can perform. And this goes to something that I think is really important to think about, at least from a policy perspective. When we talk about some kind of asset or arrangement being a security, then that presupposes that there's some sort of issuer of that security who then has a bunch of things they need to do under the securities laws, right? They have to prepare certain disclosures. They have to prepare financial reports. They need to clear their offers and sales, with the SEC if it's being made to the public. In many of these instances, you talk about Bitcoin or Ethereum, there's no real issuer standing there who has the ability to do perform those tasks. And so it'd be pretty divorced from the operation and objectives of the securities laws to consider those assets themselves to be securities, because you would have the odd situation of having a security with no issuer actually to step in and perform the duties the securities laws impose.
So I know one of the reasons this case was being watched so closely was because the industry is in a really uncertain period right now. There's not a lot of clarity on what can regulators do, who does have jurisdiction over these things. In your opinion, does this Ripple decision create any clarity, or are we just kicking the can down the road and we're still waiting for someone to definitively say who can or cannot regulate crypto?
I think it's fair to say that litigation is a really imperfect vehicle for giving the kind of clarity that you're talking about. And I say that for, a few reasons. One is this is a specific case involving a specific set of facts and a specific asset. We can certainly draw inferences from it in terms of what reasoning a court might find to be persuasive, but it's a district court decision. It's not binding precedent on other judges. In fact, just earlier this week, another judge in the same district disagreed with Judge Torres's reasoning on a different set of facts at a different set of a point of the process of a litigation. But that just goes to show that it's hard to draw a lot of certainty from a single district court decision in a single case. Now, ultimately, these matters could go up on appeal, in which case we might find in, say, the Second Circuit, there becomes some sort of law about how to analyze when an investment contract is present with respect to the offer and sale of an asset. But you have to also take into account the fact that each of these cases, the two that I've mentioned, Ripple and the other case, which is the Terraform Labs case, involve situations where the defendant is itself, effectively the issuer, right? Neither case, truly presents a situation where trading is taking place between parties who are not the issuer, which could be analyzed differently. A lesson that I think can be drawn from both cases is that the asset itself, as we've been saying, is not a security. Both judges were clear about that. You have to look at each, transaction, each offer and sale on its own facts. And so I think that means that although we have a better understanding with these two rulings, at least, as to how some courts might look at this, we don't have the same certainty that will flow from, for example, legislation, which could define more categorically which assets are and are not securities, which are non-security commodities, which should be regulated by which regulator under what set of rules. And then finally, even if we did get to a situation where there were contra to the Ripple decision, rulings at, say, the circuit court level or some other higher court level that more broadly conferred the SEC jurisdiction over cryptocurrency transactions, that also would not answer the question of, okay, how's the SEC going to apply the securities laws, to those transactions, for all kinds of questions around what disclosures are appropriate, how can cryptocurrencies be custodied, all those kinds of things, which are still largely unanswered. And so I think that it's really hard to draw a line from a single decision or even two decisions to a place where in the US we have the same type of legal certainty around these assets as what's starting to develop in some of the other non-US jurisdictions that have adopted specific regimes for them.
And when you say that that we don't have clarity on this, I'm curious because in the interest of full disclosure, you represent exchanges. You're not on the government side for this stuff. If you were the general counsel of the SEC, what would you say to this decision? Where did Judge Torres get it wrong?
I mean, I think that I think there are some things that she didn't fully address in detail, right? So there are some footnotes in the decision which are interesting. For example, the SEC made allegations that when Ripple sold to certain institutional parties and on exchanges for market makers, that those folks were also engaged in resales as essentially underwriters. And if you compare the decision in this case with the decision in the Telegram case from a few years ago, where that court, again, different procedural posture. The Ripple decision was at a summary judgment stage. The Telegram case, as well as more recent
you just
Terraform
summarize
case.
like in two sentences the Telegram case, so everyone.
Yeah, so the Telegram case involved a company called Telegram. They had created a cryptocurrency called Grams, which were going to be used as part of kind of a broader sort of mobile messaging, ecosystem. They had sold those Grams to various institutional purchasers in kind of private or offshore offerings, but the SEC alleged that that was all part of a broader scheme to distribute those tokens to the retail public, including in the United States, and that made those institutional purchasers themselves underwriters, and the entire offering, not just the initial sale by Telegram to the institutional purchasers, but the institutional purchasers later resales, part of an overall investment contract arrangement. And the court also in New York agreed with that at a motion to dismiss stage. So at that stage in the litigation, the SEC's allegations have to be taken, as true, essentially, whereas at summary judgment, there's been additional fact finding. So the Ripple case was further along than that Telegram case. But the interesting part there is that the court looked past the initial sale to the resales that did not involve a direct transaction between Telegram and the ultimate purchasers. The SEC made some analogous allegations in the Ripple case. Judge Torres disagreed with them, but on a very conclusory basis in a footnote in the decision, and didn't expand on her reasoning for why she disagreed with that. She also did not address and did not reach the view about whether there was some sort of common enterprise among the retail purchasers on the exchanges and each other, or common enterprise between them and Ripple. And I think many had predicted that if she was going to find in Ripple's favor, it would have been more on that common enterprise prong, and that one of the areas that she's been criticized on is that she instead rested her decision on this question about whether the retail purchasers had a reasonable expectation of profits based on Ripple's efforts. And I think some would say, and what Judge Rakoff said in this week's Terraform Labs decision is, look, the representations that were being made out on social media and on websites and things like that were being made sort of on a blanket basis to whoever was purchasing the asset. And so that part of Judge Torres' decision, where she suggested that the retail purchasers did not, shouldn't have been thought of as really basing their decisions on Ripple's marketing efforts. That's been an area where she's been criticized, and it seems that in the different facts, but again, analogous that Judge Rakoff analyzed in the Terraform Labs decision, he came to a different conclusion.
Do you have to know each other to be in a common enterprise? In other words, can two retail investors, if that's what the criterion is, could they be in a common enterprise because they have the same goals and they're trying to accomplish the same sharing of profits, for lack of a better way to describe it?
Yeah,
do they have to sit in a room and make that decision, or can it be enough just to be doing it?
I'll sort of tweak your question a little bit, Alan, which is that I think what you're asking is a common interest sufficient to have a common enterprise? And I think there the answer really ought to be no. Certainly, everyone who owns a particular baseball card, right, has an interest in that baseball card accreting in value. Everybody owns a everyone who is all the oil companies, have an interest mostly in oil going up in price. But that does not put them in a common enterprise with each other, even though their interests, are aligned with each other. If we think about the futures markets, right, all the people who are long a particular futures contract have a common interest, but they're not engaged in a common enterprise with each other. Common enterprise is generally thought of by the courts as involving some sort of pooling of funds, either as among different, as among different investors, which is horizontal commonality, or between the promoter of the investment contract and the purchasers.
So where does this leave us now then? Are the people who are participating in purchasing crypto and exchanging crypto, are they investors? Are they issuers? Are we going to all be on the hook to sign up for securities declarations, or what comes next?
We're going to continue to see litigation here, right? These cases are still pending. The SEC could try to seek an appeal of a Ripple decision either now, which it doesn't have a right to do. It has to be granted by the court, or later when there's a final judgment in the case. We should expect, I think, the Terraform Labs litigation that I mentioned to proceed now past the motion to dismiss stage. There's pending litigation against multiple crypto exchanges, against Coinbase, against Binance, against Bittrex. And we also have legislation pending. I mean, it's around over the same period, we've seen legislation actually get voted out of the House Financial Services and House Agriculture committees on a bipartisan basis. Multiple Democrats joining the Republicans who chair those committees to move those bills forward. We've also seen legislation introduced on a bipartisan basis in the Senate. I think people are generally pessimistic that either of those bills will become law in this Congress because of some of the opposition, certainly, that exists in the Senate and potentially at the administration. But I think that there is this is one of a few areas, I think, in this current political environment where you are seeing first of all, bipartisanship, which is not that common in this environment. Interestingly, when you look at the votes for the legislation, they don't cleave as much on partisan lines as they do demographically, with older Congress people tending to vote against the legislation and younger ones tending to vote, in favor of it. This is also an interesting area where, and Alan, I'm not sure if you've ever seen this before, where you have the same legislation introduced and voted out of both the Financial Services Committee, which oversees the SEC, and the Agriculture Committee, which oversees the CFTC, where those two committees are agreeing about how to allocate jurisdiction, between them, which, at least in my career, I've never seen that before. So I think that makes me somewhat optimistic that at some point, we'll likely see some legislation proceeding. What that looks like, I think, will be influenced obviously by future political events as well as how this litigation proceeds. But I'd be doubtful that we're going to get kind of meaningful across the board legal certainty here for at least another, probably year or two at the earliest.
Colin, thank you so much for being with us, and we're going to have you back to discuss this as more of these cases come up. And we didn't even touch on how the commodity laws work with this, but you really gave us a good foundation and sort of left the questions out there that are outstanding that the regulators are going to have to deal with, that the legislators are going to have to deal with, and that our audience is going to have to deal as they understand how the blockchain is going to evolve in the context of the investments that are surrounding the blockchain.
Yeah, well, thanks for having me. Look forward to talking to you again.
All right, thanks so much, and we'll see you all in our next episode of Blockchain Explained.
Thanks for listening to another episode of Blockchain Explained. Please note, nothing in this podcast should be construed as investment advice. Want more clear-eyed analysis of this exciting technology? Search for Digital Assets Forum at the Wilson Center for research, event recordings, and more. Want to ask our hosts a question? Write to STIP, STIP at wilsoncenter.org with your thoughts. Thanks again, and we'll see you next time on Blockchain Explained.